We're under standing orders from the Dean to be brief in our introductions. So I will be very brief. I can't speak for my colleagues. I hope they will admonish the Dean's words. This is an event of the Institute of Judicial Administration, which has been around here since 1947, around the law school. I only got involved in 1991, but I've spent a good part of my life involved with the IJA. We take pride in being a non-political, non-ideological venue, primarily for judicial education, but we also have done studies in access to civil justice, and we run annually, I guess now for the 26th year, an employment law workshop for federal judges. So this is a special forum where, you know, left and right, Republicans and Democrats should feel comfortable. And the Brennan Lecture, we also give credit to the state courts. You know, I always kid my students that it's all a capitalist conspiracy, the major law schools, because we're not actually teaching you how to litigate in the state courts, how to litigate, period, but we're certainly not teaching you anything about the state courts. And the reason for that is good, because we want you dependent on the big firms as a wage slave, the modern day wage slave, in any event. The state courts are the primary engines of justice in the country, and I understand the reasons why we teach national law. It's easier than mastering 50 laws, and you know, and ease for faculty is a good project. The Dean has motioned me to keep on. So we have the Brennan Lecture is an aspect of that. We also have very large enrollment in our appellate judges seminars by state judges, state Supreme Court and Intermediate Court judges as well. So without further ado, we go to our Dean.
Thank you, Sam. Welcome, everyone. I am incredibly pleased to be here, not just because of my role as dean, but for many years I was co-director, co-faculty director with Sam of IJA. And the Brennan Lecture was something that I looked forward to each year. This really is a hallmark event for IJA, for the law school community, because it gives us a forum to hear from and recognize leading state court jurists. Sam has talked a little bit about the role of IJA. I'm grateful to him. I'm also grateful to the chair of our boards, Evan Chesler, as well as Chief Justice McCormick, who will be, of course, our lecturer this evening. The Brennan Lecture recognizes a number of things. It recognizes, first, the role of Justice William J. Brennan from my home state of New Jersey, who began his judicial career as a member of the judiciary in New Jersey, rising to the Supreme Court of New Jersey, where he was a colleague of that man over there, Arthur Vanderbilt, after whom this building is named, who was dean at NYU and then left the deanship to become Chief Justice of the Supreme Court of New Jersey. And Brennan was one of his colleagues. I think as many of you may know, there is a story, probably not true, but still a great story, so I'm going to tell it, about how Brennan got to the Supreme Court. Brennan was a Democrat from New Jersey, appointed to the Supreme Court by a Republican president, not from New Jersey, Dwight Eisenhower, son of a union leader. How did that happen? The story goes that Arthur Vanderbilt, who was a committed Republican, was invited to give a speech in Washington, D.C. He was very busy, couldn't do it, and said to Brennan, hey, why don't you go and give that speech for me down in D.C. as my colleague? And that was sort of Brennan's introduction to important people in Washington, and the rest is history. Now, I don't believe the story, but it is too good not to tell, even though I don't believe it. But Justice Brennan, of course, when he went to the Supreme Court, did not forget the importance of the state courts. He was on the Supreme Court for 34 years. Nevertheless, even though he was an important player in the crafting of federal constitutional and statutory jurisprudence, he repeatedly reminded all of us about the principal role played by the state courts and state constitutions. And so the Brennan Lecture was launched here at NYU to help recognize that. It is also, I want to say, a testament and a tribute. This lecture is a tribute to the late, great Chief Judge Judith Kaye of the New York Court of Appeals, whose portrait is over there. Chief Judge Kaye was the initial Brennan Lecturer. She was a driving force behind the creation of a lectureship recognizing the role of the state courts, and we miss her dearly. Now, following my admonition to Sam, I will be brief, but I would like to invite Evan to the stage. And I just want to say that we are so grateful to have Evan's counsel and wisdom over the years. He has been a board member at IJA. He has been a board member of the NYU School of Law Foundation, and he is a board member of the university's Board of Trustees and has become the chair of the University Board of Trustees, which is a very, very important role and a busy role. Along the way, of course, he is a longtime partner at Cravath, Swaine & Moore, was presiding partner and chair of the firm, is an extraordinary litigator and teacher. He teaches trial advocacy here. So Sam, if students take his class, they'll know how to litigate. I know that for sure. So please join me in giving a very warm welcome to Evan Chesler.
Thank you all very much. It is my honor this evening to introduce Chief Justice McCormick, who now, of course, is the Chief Executive Officer of the AAA. And you all know the topic, the disruption we needed. As the Chief Justice of the state of Michigan, she had an extraordinary impact on jurisprudence, both within the state and beyond the state's borders, oversaw over 500 judges, championed such things as legal representation for those who could not afford access to the courts, improving the public's experience with the court system, improving the experience of criminal defendants who are awaiting trial, and many, many others. She worked for the Legal Aid Society, the Office of the Appellate Defender, the Yale Law School, the University of Michigan. There are so many awards and accomplishments that we don't have the time, given the dean's admonition, to go through them. But her most important academic accomplishment, of course, was graduating from this law school. Just one comment about the concept of the disruption we needed. During the COVID crisis, I had an argument in the Second Circuit Court of Appeals, which of course was being done by Zoom. The argument was called for a calendar call at 10 o'clock in the morning in an autumn morning around this time of the year. And I was seated at my desk at home in front of the screen, and at 9:50, my neighbor's gardener turned on his leaf blower, which at 9:51 provoked my neighbor's dog to protest the sound of the leaf blower. At 9:53, I was negotiating with the gardener and the dog, and I have to say, I did not at that moment feel that it was the disruption that I needed. So I'm really looking with great anticipation to hear what Her Honor has to say on the subject. Chief Justice.
Thank you for that kind introduction, and thank you to IJA for inviting me to give this lecture. It really is an honor. Chief Judge Kaye, it's judge in New York, right? You have the weird thing where you don't call yourselves justices, right? Was my graduation speaker from NYU Law School. I'm pretty sure that's right, 1991. Somebody can confirm. And I thought she gave a great speech, and I remember seeing my dad afterwards, who wasn't a lawyer, and asking him what he thought. And he said, it was at Carnegie Hall, and he said, I don't know, I was having a hot dog outside. Literally left the graduation to have a hot dog. So I thought she gave a great speech. It is wonderful to be here with so many friends. I have mentors in this audience, people who I think I owe the successes in my career to, and mentees, and it is wonderful to see all of you. You know my topic. I'm going to talk about the disruption that courts have experienced over the last few years, what we've learned from it, and what it means for the rule of law. I'm going to ground my argument in two concrete ways to make it more tangible. First, I'm going to focus on the massive market failure of the civil justice system as context for evaluating pandemic changes. And second, I'm going to focus my discussion on Michigan because my experience there allows me to discuss this topic in some meaningful detail. But the Michigan courts are not special. All courts face the same threats and opportunities. I want to start by contextualizing the state of our civil justice system. The Legal Service Corporation's 2022 Justice Gap report found that 92% of the civil legal problems of low-income people get either no or inadequate legal help. That's a 6 percentage point increase over the prior study from 2017, and it wasn't a pandemic blip. During that same period, total revenue to legal aid programs increased by 31%. The National Center for State Courts measures the number of people navigating courts without lawyers, and it estimates that both parties have lawyers in only 24% of civil cases in state courts. And that's where almost 95% of civil litigation occurs. Here's another one. Every year, the World Justice Project ranks the world's countries on their compliance with various measures of the rule of law. One of those measures is the accessibility and affordability of civil justice. The most recent Rule of Law Index, released late last year, ranks the United States 115th out of 140 countries on the accessibility and affordability of civil justice. Among the 43 wealthiest countries in the world, the United States ranks 43rd. The cases that litigants manage on their own are not cases we teach in law school, for the most part. They rarely get appealed, but they are high-stakes cases involving shelter, personal safety, family, financial stability. I wish law school started with 1Ls watching civil court dockets in state courts, eviction dockets, debt collection dockets, family court dockets. I imagine it would spark some solutioning that those of us many decades into our legal careers have a more challenging time seeing. It would starkly contrast with the rest of law school, where we read appellate decisions handed down in cases where both parties are represented by lawyers who present evidence and make legal arguments for their clients, and the best legal argument wins. This is a relatively new problem. While state court data is opaque, our evidence shows that lawyerless litigants were the exception as recently as the start of the last quarter of the previous century. That's such a confusing sentence. I'm sorry I wrote it. I really feel bad having said it. The numbers we see today, we have seen since about the early 2000s. That's a little clearer. But it wasn't this way as recently as the 1970s. In 1977, 2 Yale law students studied 2,500 divorce cases in 2 trial courts in Connecticut, and they published their results as an unsigned project in the Yale Law Journal. The students were Deborah Rohde and her husband-to-be Ralph Kavanaugh. They found that 2.7% of the divorce cases they studied involved an unrepresented litigant. They cited a then recent study in San Mateo, California, showing that 20% of divorce petitioners were proceeding without lawyers, a figure they characterized as a, quote, unprecedented surge in self-representation. Like every other state, the bench and bar in Michigan have focused considerable attention on the civil justice gap for decades. We have best-in-class legal aid programs, innovative law school clinics, and a generous giving history by law firms and individual lawyers to the state bar's Access to Justice arm, which funds legal aid programs throughout the state. Our vision for addressing the civil justice gap went beyond the one-to-one service model for traditional lawyer-client engagements. We recognized that we were not going to pro bono our way through the access to justice issues we faced, and we've therefore built programs and tools to support the many people navigating justice issues who would never have access to a lawyer. A partnership between the State Bar, the Michigan Supreme Court, and the Legal Services Programs set up what I believe is the best online site to help self-represented litigants in the country, Michigan Legal Help, in 2012. Michigan Legal Help is a website that provides reliable legal information and self-help toolkits that produce forms for court proceedings for people navigating justice problems without lawyers. There are also Michigan Legal Help centers in courthouses for people who need a little more help with the website's toolkits. The team at Michigan Legal Help has chatbots and takes email questions after hours. They work with judges, courts, lawyers, bar associations, nonprofit legal aid agencies, other legal help, self-help centers, libraries, to promote the website and its toolkits. And when Michigan Legal Help struggles to support users in certain use cases, we looked for other solutions. So for one example, we could see that most users of the expungement toolkit never finished it. It was too complicated. Expungement was statutorily complicated. It used to be in Michigan, it's not anymore. We made it really easy. We just do it automatically now. That's a different speech. But it was complicated, and people couldn't make their way through the toolkit. So the court and the bar collaborated with the Detroit Law School, formed a traveling clinic to travel around the rest of the state and do it for people. Everybody who had tried, we went and found them and did it for them. In May 2019, the Michigan Supreme Court formed a task force to assess the civil justice system comprehensively, partnering again with the Bar Foundation and Michigan Legal Help, and with funding from the National Center for State Courts. The Justice for All Task Force set out to do a statewide inventory of available resources for people with civil legal problems, identify any overlaps, identify gaps, and develop a strategic plan to address the civil needs of every Michigander. Also in late 2019, the Michigan Supreme Court Administrative Office stood up an online dispute resolution service in 17 of Michigan's 83 counties. It's called MyResolve. It's a user-friendly platform. It's asynchronous. It's absolutely free. Parties can do it with a mediator or without. It's up to them. And they can avoid court altogether for small dollar civil disputes. In other words, in 2019, we thought we were doing a lot to address the civil justice crisis in Michigan. I was at the time the chair of the Conference of Chief Justices Access and Fairness Committee, and I felt pretty confident we were doing as much as, or significantly more than, many other states. But despite the bench and the bar's focus and effort, the civil justice crisis was not improving. Our imaginations weren't big enough. The tools and the processes we have traditionally used have been lawyers' tools and processes. That is, they are careful, incremental, measured, and largely biased in favor of the one-to-one service delivery model. We needed a legal service delivery Uber or Netflix. But lawyers are not generally skilled at building disruptive models, especially models that disrupt themselves. For many reasons, lawyers are not well equipped to solve problems requiring transformation, innovation, and collaboration. It's culturally a bad fit for us. We teach a one-to-one legal services delivery model where every client has a lawyer. Most mindsets that make a great innovator are not super compatible with ethical legal practice. Failing fast is excellent for Sam Altman, but there aren't many legal settings where failing fast is a great idea. Our training and culture are risk-averse and backward-looking. In law, incremental change is often the path to lasting solutions with less conflict. And lawyers are committed to the way we have always done things. One of our most essential decision-making norms is backward-looking. Stability and predictability require it. That's what we teach. And there is a strong cultural bias in favor of the status quo. We did it this way, so you should too. How else do you make sense of our unchanged licensure system? Part of it is practical. A true transformation of what we do and how we do it would require coordination across stakeholders who rarely interact and are all busy with emergencies. Law schools, their accreditors, state bars, bar examiners, and state Supreme Courts own different parts of lawyer formation and legal service delivery, and they rarely interact. We each focus on many critical immediate problems preventing us from collaborating on structural problems. I've been meaning to write a law review article for 30 years that has a great title, but no pages yet. It's called Let's Do Emergencies Last. While working in good faith to address the immediate problems squarely in their wheelhouses, stakeholders don't have room to step back and explore upstream solutions to a failing justice delivery system. There's also no obvious funder for disrupting the status quo. There's little regulatory room for disruption by folks outside of the profession, and there aren't resources for those inside of it. Except for those lawyers in big law, a very small minority of those in the profession, lawyers' priorities are structured around financing their practices and paying their employees. Courts struggle to keep the lights on, judges trained, and pay staff a living wage. Funding for technology, data collection, evidence-based study, and reform is minimal. And the competing priorities of dispensing daily justice are formidable. Finally, if that's for me, tell them I'll call them back. It's okay. I'm gonna grab water. Is that okay? You wanna pour me one, Sam? Thank you. I appreciate that. Finally, unlike the rideshare industry or online shopping, justice solutions are delivered primarily through courts, a branch of government funded by another branch of government, thank you so much, funded by another branch of government and staffed by elected judges in many places. Those government systems are structurally complicated, organizationally bureaucratic, and often impenetrable. Users likely find them at least as unworkable as department stores or Blockbuster. But operating a monopoly outside the discipline of the market makes disruption far more complicated. Take Michigan again. The Michigan courts adjudicate over 3 million cases every year across 242 trial courts. The Constitution vests the Michigan Supreme Court with administrative oversight over all of the state courts, which it exercises through rulemaking, programs, training, and some funding through the State Court Administrative Office. Among other administrative functions, the Supreme Court Administrative Office supports and trains judges and court staff across the state. The day-to-day operations of our trial courts, however, are managed by local administrators, acting under the supervision of a local chief judge. That local chief judge was elected locally in nonpartisan elections, and the Michigan Supreme Court appoints the chief judges. By law, the local county clerk, also an elected position, is designated as the circuit court clerk, but does not work for the court system. That means the clerk performs functions for the judicial branch, but is not directly subject to the court's supervisory authority. Trial court funding is similarly complicated. The state funds about a quarter of local trial court budgets, local government funds about a half, and the rest is generated by courts, costs assessed on litigants. Federal funding can account for a very small part of that. Where in that complicated structure would a disruptor get a foothold? It is a daunting change management landscape. And the result is a growing civil justice crisis that has gotten away from us. The incremental access to justice work that the bench and bar have taken on year after year is no match for it. The pandemic changed almost everything about how courts operate, at least temporarily. Not just what we did, but how we did it. Faced with managing a busy court docket that relied on cramming strangers into small spaces with no ventilation, we were forced to innovate and collaborate. We couldn't stop adjudicating cases, but we had to keep everyone safe. In Michigan, we were fortunate to have a running start. In 2010, the Supreme Court Administrative Office began implementing a video conferencing project to equip at least one circuit, probate, and district courtroom in every jurisdiction with that hardware. And a year before the pandemic, we distributed Zoom licenses to every trial judge in the state, which sounds like we were clairvoyant, but we weren't. Michigan is just enormous, and we thought it might make sense to bring some efficiencies. But as a result, in March 2020, every Michigan trial judge was equipped to quickly move their proceedings to the Zoom platform. But because the day-to-day work of every court depends on those separately elected county clerks who keep our records and county commissions who fund those courts with their staff, we set up a rapid response team made up of representatives from all three of those organizations to put out emergency guidance and training and other support on a daily basis. The Supreme Court suspended rules and processes, like most Supreme Courts did, that were barriers to remote proceedings. By emergency order, we issued 24 pandemic-related administrative orders in 18 weeks. To maintain public access to courts, we required our courts to stream their virtual hearings to the YouTube platform or upload them immediately afterward. In May 2020, the Supreme Court's IT team built and launched an online virtual courtroom directory that was a user-friendly interface that allowed anyone, anywhere, to watch virtual hearings in any courtroom by clicking a link. This kind of tool typically would have taken the team 6 months from concept to launch. They built it in 3 weeks. With a smartphone, anyone could easily find and watch proceedings in any court. Judges, court administrators, and litigants quickly discovered what worked online and what didn't, and experimentation was encouraged. By the end of 2021, our trial courts had conducted nearly 5 million hours of online hearings. Michigan residents had used the virtual courtroom directory to find a hearing on YouTube more than 450,000 times. And collectively, the trial court YouTube channels had nearly 185,000 subscribers. Michigan Legal Help's traffic increased dramatically. In the last week of March 2020, visits were up 30% over the previous week, and up 112% from a month earlier. We were seeing approximately 17,000 website visitors per day, almost 123,000 per week. Help chat and after-hours email traffic doubled, and the most common topics people were seeking help with were unemployment insurance, eviction, child support, public assistance. We also significantly sped up our efforts to move the MyResolve, the online dispute resolution platform, to the remaining 66 counties in the state. And we did it by July 1st. By July 1st, every single person in Michigan had access to online dispute resolution and did not have to go to court for their civil justice problems. Not only were we able to keep our courts operating, but we could measure the value that the technology and other changes provided our court users. Virtual hearings reduced or eliminated transportation and parking problems, as well as childcare and work conflicts. Recording the proceedings was seamless, and the number of people who could witness any hearing was infinite. More than 7,300 people watched live a court hearing on a challenge to the governor's emergency powers. If that had happened in a courtroom, 45 might have watched it. The Michigan Supreme Court pushed the link out on its Twitter and Facebook feeds. Pandemic innovations were not only technology-based. We worked swiftly with other government branches to establish a statewide eviction diversion program funded by the American Rescue Plan. We sent the program design to other states who copied it and immediately stood up the exact same plan. Many court leaders around the country were agile. The Justice for All Task Force moved its work online, but kept on schedule. Online surveys and Zoom meetings worked quite well for the inventory and public input, and the task force report and recommendations were released in late 2020 on Zoom. They were creative and they were bold, and I believe the background innovation in the legal profession produced more innovative recommendations. The court wasted no time setting up a permanent Justice for All Commission to put the recommendations into practice. Innovations also spread from state to state due to formal and informal collaboration by the Conference of Chief Justices and the Conference of State Court Administrators. CCJ and COSTA stood up rapid response committees to address the issues courts faced. These committees were producing weekly deliverables, from training materials to emergency order drafts and data collection. I had a weekly Zoom call with the Chief Justices from Ohio, Indiana, and Kentucky, which was invaluable. We still go to Canyon Ranch in the summer together. Not Kentucky because he's a man, but Ohio and Indiana and I do. We like him, but not for Canyon Ranch. The pandemic was also a growth mindset for other access to justice innovations unrelated to keeping people safe. The Utah and Arizona Supreme Courts adopted regulatory changes in 2020 and 2021 to address the civil justice failures in those states. In 2020, the Utah Supreme Court established a regulatory sandbox that allowed legal service providers to test innovative offerings in a controlled environment while being monitored for consumer protection. The Licensed Paralegal Practitioner Program enables qualified non-lawyers to provide limited legal services in debt collection, landlord-tenant disputes, and family law matters. To become an LLP, individuals must possess an associate's or bachelor's degree, complete an approved LPP education program, exams, and apprenticeship. LPPs must adhere to professional conduct rules and complete 12 hours of continuing education annually. The Utah LPP program aims to address substantial unmet legal needs while maintaining consumer protections through licensing, especially among low and moderate income people. In 2021, the Arizona Supreme Court followed suit and adopted rules to create a new licensing program allowing qualified non-lawyers to provide legal services in family law, landlord-tenant disputes, debt collection defense, and administrative appeals. They can prepare legal documents, advise clients on procedural issues, and represent clients in certain administrative hearings. Legal paraprofessionals must meet specific education and training requirements approved by the court. They're bound by the rules of professional conduct and complete annual continuing education. In addition to creating the legal paraprofessional program, the Arizona Supreme Court amended Rule 5.4 of the Rules of Professional Conduct. As you know, Rule 5.4 prohibits lawyers from sharing legal fees or forming partnerships with non-lawyers for law practice. The rationale for this rule is to prevent outside influence over lawyers' independent professional judgment. Arizona's revised 5.4 allows for alternative business structures and non-lawyer ownership of law firms in Arizona, provided specific requirements are met. They're testing the idea that more flexible rules might facilitate investment in innovation and technology solutions for cost-effective legal services. We learned a lot. Statewide eviction diversion kept millions of people in their homes while making landlords whole. And while in hindsight, some of what we learned about remote proceedings shouldn't have been surprising, the benefits for self-represented litigants were incredibly impactful. People who would have missed a court date because they lacked access to transportation or could not afford to miss work, or were spared the consequences of failing to appear. Jail, fines, housing, lost housing, separated families, and more debt. Default judgments plummeted. The Michigan Supreme Court's research team found that the percentage of Michigan civil cases ending in default judgments fell by 17% between 2019 and 2021. The data showed a 38% decrease in the rate of defaults in landlord-tenant cases during that same period. There was qualitative evidence of benefits too. For example, participants in guardianship and conservatorship hearings reported increased satisfaction with access and the ability to participate. These benefits, which I have seen firsthand in Michigan, have been well documented now. Interviews with judges who oversee child welfare courts found that parents, foster parents, kinship caregivers appeared more often at virtual proceedings, and they attributed that increase in part to not having to travel, find parking, miss work. In addition to the efficiency and access gains, remote hearings offer extra protection and reduce the stigma of reporting sensitive matters such as domestic violence. There's also evidence that online jury proceedings increase jury participation and representation because jurors also don't have to find transportation or childcare and can have flexibility in serving from home. We knew some of these benefits before the pandemic. In 2020, the Joint Technology Committee of the Conference of State Court Administrators, the National Association for Court Management, and the National Center for State Courts published some studies about ODR programs nationwide. In Franklin County, Ohio, using ODR for city income tax cases led to fewer default judgments and a more even distribution of positive case dispositions regardless of socioeconomic factors and race. Utah used ODR as part of a restructuring of its small claims process. The program has led to fewer hearings and faster dispositions in cases that do end up in court. In Connecticut, ODR has been used to create an online ticket review program for traffic court. Most ticket recipients chose to opt into the program, which has shortened days from citation to adjudication significantly. When it was safe to go back into courts, we had choices. We could go back to doing things the way we always had, or we could take account of this new data that giving people remote options and collaborating to find new solutions made it more likely that they could resolve their disputes and more likely that they would be represented. Courts make the rules about how they administer justice. In addition to the benefits we saw for litigants, remote proceedings could be part of the solution to trial court backlogs because of their increase for capacity. Visiting judges can conduct remote proceedings for matters suited for those proceedings, freeing up physical courtrooms for jury trials and other proceedings better handled in person. And the efficiency of remote proceedings would only improve over time as courts, attorneys, litigants, and other stakeholders became more familiar with new processes and technologies and maybe their neighbors' gardening schedules. But with some exceptions, courts have returned to doing things like they did in 2019. Back to Michigan again. We published a rule change to take public input on whether to continue doing many hearings remotely. Whenever we publish a rule change, we take public comment in writing for a number of months, and then we schedule a public hearing, and anybody can show up and talk to us about it. The public hearing on that rule change was the most attended public hearing in my 10 years on the bench. We limited people to 3 minutes, and we were there all day. The lawyers and members of the public who spoke were overwhelmingly in favor of the proposed changes. The judges were overwhelmingly opposed. The court adopted the rule change, but with 3 dissents. I responded to my dissenting colleagues in a concurrence to the order. My view was that the judiciary should not be the only institution that doesn't benefit from the lessons learned from the pandemic and the accelerated innovation it brought. And more importantly, the public shouldn't lose a valuable new tool for accessing justice. Like the rest of government, the courts are for the people, not the judges. Some other states have integrated remote operations into their permanent administration, but you might be surprised by which ones. Alaska, Arizona, Illinois, Minnesota, Maryland, North Carolina, and Texas. In Florida, the state Supreme Court encouraged judges to, quote, take all necessary steps to support the remote conduct where possible to maximize the availability of facility space for trial court proceedings that must be conducted in person, so Florida sorta. Michigan also made some of the successful eviction diversion program changes permanent. I'm not aware of any other state that took that step. The pandemic also led to significant changes in federal courts operations. I know that's not what tonight's about, including allowing public streaming of remote proceedings, but most of those changes were temporary. While some flexibility remains, I understand, for initial appearances, the federal procedural rules require in-person testimony and restrict broadcasting for many proceedings. Overall, the federal court system is transitioning back to how it operated before the pandemic, unable to permanently adopt many of the remote options authorized under the CARES Act. At least they don't have any cases over there in federal courts. So in most places, 2 steps forward, 2.5 steps back. I assign the extra half step because once you know you can do better and choose not to, you do more harm. When you ask people who need courts how they feel about reforms that give them more options for getting help, they have views. As I mentioned, the public input on the remote hearing rule in Michigan was loudly and clearly in favor of increased remote options. When the Arizona Supreme Court was working on its regulatory reform package, it held public meetings and sought public feedback through surveys and discussions. Lawyers surveyed about the reforms were overwhelmingly opposed. It was something like 89-11. And the public surveys produced the exact opposite results. And that input ended up playing a significant role in the success of the reforms. We hear and read a lot about polarization and partisanship threatening to undermine the independence and the integrity of our judicial system, and I believe those are real threats. Public confidence in courts is declining. Federal courts more than state courts, but state courts too. You know, very few people under 40 call the justice system the justice system. None of my kids do. They're in their 20s. But I think the inability of courts to embrace changes that give people more options to access justice is at least as significant a threat. Today, about 1,400 eviction cases were heard in the Detroit District Court, and many of them ended in defaults because most people didn't show up. And for those that did show up, they struggled to understand the language spoken in those courtrooms. Some of them probably had defenses, but very few would have known how to figure that out. Tomorrow there'll be another 1,400. The rule of law is just a set of ideas that depends on the public having confidence in those ideas. What happens if the public loses confidence? What if when the rules don't seem to care about you, you stop caring about the rules? Disruption is almost always a threat, but it's also an opportunity. We can reconstruct what courts are so they better reflect and better serve all Americans, if we want to. I see one big plot twist on the horizon. I think generative AI is disrupting the business and practice of law already. I think the large language models that are publicly available right now are already able to automate many of the repetitive tasks that lawyers do. And they can and will democratize legal information and accelerate legal singularity. They're going to even a lot of playing fields. You likely followed ChatGPT's bar examination success. In November, GPT-3 did not pass the bar, passed two of the multi-state topics. GPT-4 in March not only passed it, it scored in the top 10% and it did it in 6 minutes. Change is coming. Even the stickiest problems and the most opaque bureaucracies are headed for disruption. What's to stop the TikTok legal influencers? I hope there are some of you in the room. I don't see any. I hope you're here. But what's to stop the TikTok legal influencers from posting videos telling self-represented parties exactly what prompts to put into ChatGPT to produce an answer, a counterclaim, a demand for discovery, a demand for a jury trial in every eviction case? Lawyers are hardly ready for the disruption that's headed our way. Courts are far, far less ready. But we could be. Lawyers and judges can lead the change we'd like to see if we want to. The rule of law is our best hope for just, free, and equitable communities. But it requires the public's confidence, and that's wobbly. Thank you very much.
Thank you. What a great presentation. Thank you very much, Chief Justice McCormick. We have time for questions or comments. I ask you to identify yourself, if you don't mind, with your name and sort of who you work for. Any takers?
I'll talk to him.
Oh, sorry, Abby.
That was terrific, thank you. I'm going to ask a provocative question about access. Let me say that's the one. Here. Hi, I'm Abby Gluck. I'm a professor at Yale Law School and a great admirer of Chief Justice McCormick. I want to ask a provocative question about the access to justice benefits from ODR. There are some people who think that the result could be the opposite. If you have a two-tiered system where poor people are not inside courtrooms, not seeing judges in their robes and being, getting justice out of kiosks, right? So I think one of the questions about ODR is how to stop us from having sort of a two-tiered system. And the medical analogy, talking about the paralegals, obviously reminds everybody of nurse practitioners and how they've democratized medical practice, and that's very valid. But poor people get their health care in the emergency room at CVS, and rich people get their health care from doctors. So a question is, how can we move forward without creating a two-tiered system for poor litigants and everyone else?
Yeah, it's a great question, and the medical example is striking. I think this is right, you'll know better than I will, Abby, but I'm pretty sure that medical care is provided by an MD or a DO in like 11% of the cases, and 89% get their medical care from some other licensed medical practitioner. And legal care is provided by lawyers 80-some% of the time. Only lawyers can provide legal care. And so whether, whether there's two-tier justice would be a great question if that second tier was getting any justice, right? Right now, you get an eviction notice and you just move out of your apartment, right? You get a debt collection notice and you just assume you don't have any defenses. So I'm always curious about who the people are who are so concerned about this, that other tier, and whether they're the people who are necessarily benefiting from the first tier. Because an awful lot of people, when surveyed, are very happy to have a legal nurse practitioner help them with their debt collection notice rather than no help at all.
You know, it's not just debt collection. In employment bar, the lawyers are not there for 80% of the workers.
Oh yeah, that was just my,
I mean-
you want me to get me going?
Go-
I got a lot of other material. We're all over.
Pam,
Thank you so much. This was, should I grab the?
could you identify yourself, Pam?
Wow, service with a smile. Okay, thank you so much. This was really tremendous. I was wondering if you could speak
Pam
more.
Bookman, who's
I'm sorry, Pam
who-
Bookman. I'm a visiting professor here. I teach
from
at
Fordham.
Fordham. The question is about coordination among states and the inconsistency, it seems, of the sort of justice being provided across states and what can be done or you have done to sort of get more states on the same page. It seems like a greater constellation of states than one might imagine is sort of on the same page, but there are still huge gaps.
Yeah, it's such a great question. I will say that one of the, I hope, lasting benefits of the pandemic was a really energized CCJ and COSCA and continuing collaboration, at least among the states that were leading the way in civil justice reform. So Texas and Michigan work together all the time. Texas was Chief Justice Hecht was my very best partner on every single effort. And that, that's true for my successor and Chief Justice Hecht as well. But you're right, there are other states that just never got in the game. I mean, they kind of had to get pulled into the remote hearing game because everybody had to eventually. Remember when we all thought we were gonna go back to like work in 2 weeks? So eventually everybody had to get pulled into the remote hearing game. But I think the difference is the states where you see collaboration and innovation are all either have an innovator as the Chief Justice or an innovator as the state court administrator. The state court administrator is good enough. If you have that person and the Chief Justice lets them fly, that'll work. But it's one of those is the recipe for whether you're engaging across state lines. And that's a crapshoot because we elect our judges in most places, not here.
In the rear, is that Judge Katzman?
Gary Katzman, I'm a judge of the United States Court of International Trade, and I'm the judge of the Massachusetts Appeals Court.
I'm gonna give you the microphone.
And a
so I
member
make
of
sure.
our IJ faculty.
It's wonderful to be here, and your remarks were absolutely wonderful. Thank you.
Thank you.
Just to play devil's advocate a little bit,
Sure.
and also to get your perspective, there are those who will note the great advantages generated by the pandemic in terms of access to hearings, the ability to access hearings remotely, but they will also talk about the impact, some of it negative, on the quality of the lawyering experience, the ability of young lawyers to know how it feels to actually be in a courtroom, And this is some of the criticisms. And also the fact that lawyers have less opportunity to chat in the hallways, to try to effectuate justice when essentially we're living in a world of tiles. I'm wondering if you could comment on that.
Yeah, I've definitely been in lots of conversations about that topic. There are a lot of lawyers concerned about whether the next generation will get the training and experience that it needs to, I guess, provide the kind of service that maybe most places are going to go back to. So maybe they do need that training. One of my answers is, I think the world is changing and training might need to be different, right? We might need to train people for a different kind of legal services delivery, or at least be able to train some people for it. And my second answer is, I want to encourage lawyers to be more innovative, the same way I want courts to be more innovative. And maybe there are ways to actually get through those barriers. I've actually seen some examples of that. So there are some innovators out there figuring out the ways through those barriers. And then my final answer is, at the end of the day, it's the people with justice problems that I'm most worried about, because there are so many of them. And I think, we all depend on the public having confidence that what we do makes a lot of sense, and if it stops making sense, then we won't have to worry much about training. So I think we have a bigger problem on our hands. Thank you for the question.
Other questions or comments? Mayor? Mayor Fetter,
Thank you. Mayor Fetter from Jones Day.
and a slight relation to Abby Gluck.
Yeah, no academic affiliation except by marriage. So I thought that some of the numbers you mentioned at the outset were really striking about the changes over the last 50 or so years. I guess I'm wondering whether you have any insight into what produced such a huge change, because that obviously would bear to some extent on what can be done about it.
Yeah, I think what produced such a big change has more to do with policy outside of courts than inside of courts, economic policy. And, I think we have, complicated societal problems as a result of economic policy over the last 5 decades that land in courts. Courts are downstream solutions to upstream problems that they don't create. And but they're the last solution there. So I think there are economists and policymakers who are much more articulate about that than I am. But I think that this is not a problem of courts making. It's a problem that was made in other branches of government. But we're stuck with it.
Other questions or comments? Evan?
The dean has one.
The dean, couldn't see him. I'll stand.
Troy McKenzie, no relation to Abby, but friend. So I wanted to ask you about culture and consumer protection. My background is in, among other things, bankruptcy. And I spent 4 years as a reporter to the Judicial Conference's Advisory Committee on Bankruptcy Rules, where my job for 4 years was to try to create a simplified form that could be used by ordinary people to pursue a Chapter 13 bankruptcy case, which is used by people of modest incomes who, typically are trying to save their house and the like. And it was a complete failure. Why was it a failure? One, lawyers in the field responded to this effort in the following way. It was you were disrespecting what we do. You think that because we represent day-to-day consumers, what we do is not hard. You think what we're doing is simple. It can be automated and put in a form. And I tell my students, Chapter 13, that was a lot harder to understand than a big business Chapter 11 for lots of reasons. The law is more complicated. The consequences are severe for individuals. You get it wrong, people can lose their houses, they can be out on the street. But getting past that lawyer culture barrier was incredibly hard because it was, you think what we do is so straightforward, you can mechanize it. It wasn't even about you're taking money out of our pockets, it's you don't respect what we do. The consumer protection piece is related to that. When you unbundle legal services, which is essentially what you can do through automation or through bringing in different licensure regimes, what happens in that tail end of cases where something goes wrong? So, you have a lawyer for one piece of your case, but the rest, the lawyer is not on the hook for. And if something goes south, who is there to catch the litigant when the litigant falls? And how do you deal with that? And how do you quantify what percentage of cases that's going to be? Because maybe in 90% of the cases, it's okay to have lawyers only for some small slice of the representation. But what do you do in the sort of the disaster or the emergency case?
So they're actually keeping track of that in Utah and Arizona. They're collecting data on all of the representations by non-lawyers first of all, every whatever you call it, LPP or LP, depending on the state, has to register with the sandbox office, and then has hefty reporting requirements, much more serious than lawyers have about their day-to-day work, because the court is tracking consumer harm. And David Engstrom and that team at Stanford did a study on 2 years worth of data in both of those programs, and the consumer harm was extremely low, lower than by lawyers. So I think in medicine they license, I don't know, like 99 different kinds of people, and each licensure system keeps track of harm or not. If your question is what happens if someone's harmed when there is no legal service delivery, that's happening now every day, all the time. And apparently we don't care. So I don't know, if we could have a little less of it, that seems okay to me. The cultural problem is enormous. Lawyers, California was en route to have its own set of licensed paralegals or whatever they were calling them, and lawyers killed it. Lawyers killed the program. I think in addition to lawyers, judges are just or more of a problem culturally to change. The dissenters in my court to adopting permanent remote hearings talked a lot about how we need the majesty of the courtroom and blah blah blah. And I'm thinking, like, nobody with a debt collection notice gives a crap about the majesty of your courtroom. They want a solution to their problem. They don't even want lawyers and judges. They want a solution. That's all.
If I can invoke moderator's privilege, I have a question.
Oh.
Don't worry.
Okay.
I'm not that insightful, as many people in the room can tell you. What do you think of the pro bono programs of law firms? I'll just give you one slice from employment law, which is my principal area. I cannot get management lawyers to get involved in pro bono if it involves employees, because there may be a 0.0009 possibility of a position conflict down the road. Seems to me highly unlikely. If it were to happen, then you get out of the representation at that point. So that's an example of a cultural barrier. But do you have any sense of these, what the law firms, they're doing a lot, they say, on pro bono.
They are. They're doing a lot.
And could they be doing more or different things?
Oh, I don't know about that. I mean, I don't know how many, I don't know enough about any particular law firm's economic models to know if they could do more. I mean, I saw
Are they doing a lot in
PBI.
this area of dealing with ordinary citizens and their claims?
Some do some.
Some do,
There
yes,
are some big law firms that do some work in these state civil court dockets.
Yes.
But you're not going to pro bono your way out of this problem.
No, but you can improve it, mitigate it. Like many of the things you're talking about, you're not ending the
We
problem.
need a much bigger solution.
Okay, gotcha. But could you identify yourself?
Thank you for the talk. The AI part that you've mentioned.
Can you identify yourself, please?
Sorry, I'm Carolyn Foley. I'm from your class.
I know.
And So AI, like the idea of AI, I think you're totally right? That's just going to take over everything. But at the same time, AI is terribly scary. And I worry in what you posit, that if you follow the money behind AI, like, do you have any thoughts about how you would actually implement it to serve your population that you're trying to serve, as opposed to having it distorted in some way or another? If your idea does sort of get some hold, which would make a lot of sense, but at the same time, the money then behind it, there's going to be a moneyed interest behind it that may not correspond with the people you're trying to serve.
Yeah, maybe not, right? There's so much of it that's open source now. So I think there are a lot of possibilities for, I mean, I don't know what the financial upside would be in producing, eviction defense tools. I mean, maybe there will be one. It's hard for me to imagine it. Oh. Yeah, I don't know who can prevent it. I mean, they let the cat out of the bag in November, right? They just sent it out into the world, and now it's in the world. And the next version, GPT-5 apparently makes GPT-4 look like a baby. So it's out in the world, and all three major cloud providers now interact with one of the LLMs. So you can code with it. I mean, anybody who wants to build something now can do it. So it's just going to open up so much possibility. I don't think any of us know exactly how it's all going to turn out. I'm actually teaching a seminar on it at Penn this fall, and one in the spring on AI and access to justice. So I'll tell you what I figure out. But I figure I can't even write the syllabus for January, because every week it's mind-blowing changes. So we'll see, but I think it is the biggest opportunity to solve some of these problems at scale that I've seen in my lifetime.
Evan?
Thank you. Evan Chesler, he did my resume, so I don't have to do that. Do you see a distinction between bench proceedings and jury proceedings in terms of remote justice? I mean, I've tried a lot of jury cases, and there's a sociology that develops among jurors, notwithstanding the admonition that they can't discuss the case before they deliberate. They are living together in this little microcosm. They're eating together often. You can see them. There's as they move in and out of the courtroom, they're beginning to form relationships and bonds with each other, which is different if you put aside the majesty of the courtroom point that you made before. If you're standing before a judge, it really doesn't make a heck of a lot of difference whether we're standing like this or we're looking at each other on a screen. You know what your job is, I know what my job is. But it seems to me there may be a difference in terms of even due process that a defendant might be able to argue has been diminished when the jurors are tiles on a screen. They never actually live together in the jury experience. Do you see that as a meaningful distinction?
So I am more interested in what evidence we have to inform the answer to that question, which I've been in so many of these conversations post-pandemic about what would work well remotely in terms of courts and proceedings and what wouldn't. And I can't tell you how many judges and lawyers have really strong opinions about all of that you could definitely do this, but you could never do this. And I always patiently say oh, that's so interesting. Tell me about your data. I would love to hear your evidence. And they're always well, I just know it in my gut. They're like, I'm a lawyer. I'm really, I know that I need to be in person because I'm so persuasive. And they don't have any evidence. It's we hate evidence. Why do lawyers hate evidence? Why do lawyers and judges hate evidence? We're not interested in evidence. But because the little evidence there is, they did a lot of jury trials in Washington State and Texas, not a lot in Texas, but they did enough in Texas and one other jurisdiction. And the lawyers were extremely happy with them. And the jurors were too. So I don't know, I would want to run a whole bunch more experiments and collect some data. I really think we should move in the direction of medicine, at least in terms of caring about evidence. I would like to see us care about evidence.
Yeti?
Hi, I'm Edie Wu. I'm a 3L here at NYU. I was wondering if there were ways you thought about preventing channels to access justice from being weaponized by parties with greater resources. So, for example, debt collection parties robo-sign a lot of claims, and in that way bring a lot of claims into the courts. Do you think when there are reforms that allow for Zoom access or greater accessibility in different ways, like AI, that those are still going to be used in greater and more sophisticated ways by more advantaged parties?
Or you can fight back better. So I love the question because, and so you're so right about the debt collection cases. So many of them end up getting filed, and they don't comply with either court rule requirements or statutory requirements. But there's nobody to figure that out because the self-represented party usually doesn't even show up, and if they did, they wouldn't know how to figure out what the statute requires in terms of the filing, and courts are too busy and overworked. So there are 2 or 3 courts in rural jurisdictions in Pennsylvania that we've just identified that have like one woman who's taken it upon herself to go through and make sure that the filings that are coming from these debt collections are actually meeting the requirements, and apparently that woman is reducing her court's docket by like 79%.
Wow.
just by like making sure
Wow.
that they, and my first thought was like, we could build an AI to do that in every court and like reduce debt collection cases in a minute. So it's a really good question, and I think you're right to be worried about the way it could be weaponized, but let's start thinking about the ways it could fight back.
In the rear.
Hi, Chris Anu. Ooh, sorry, loud. Chris Anu with the New Jersey Attorney General's office. I'll bite. As the president of the American Arbitration Association, where do you see arbitration fitting into all this? As a laboratory for state courts to follow, as reducing the workload? How do you see it fitting in?
It's a great question. It's one we're spending a lot of time on, as you might imagine. The American Arbitration Association is a nonprofit. It was founded with the explicit goal to provide support to the courts, to provide more access to justice. And we view it as part of our mission. We're about to celebrate 100 years, for the next 100 years to be an excellent partner to the courts and figure out what are the solutions that we might be able to help with and build and partner with to solve some of these problems. We'll have some announcements coming, but we're talking to Andy Perlman at Suffolk, and we're talking to Columbia, and we're talking to a number of law schools and partners about what we might do in this space to be a leader. I think there's lots of good opportunity. We have a really talented IS team. We have a really talented legal team. I'm not only saying that because my chief legal officer is here tonight, but we do.
Eric Tucker.
And we want to be really good partners.
Judge?
Hi, I'm Helen Friedman, and I'm from JAMS, one of your competitors.
We don't have competitors. It's a big pie.
Okay, not really.
It is. You guys are told that. Believe me, it's a big pie.
No, I know it's a big pot. I meant not really that we're a
Oh, yeah,
competitor.
yeah. With you. Gotcha.
But one of the issues that keeps coming up is the forced arbitration and the problems that so many people sign consumer reports, consumer contracts, and are forced to go to arbitration, and they always give up their rights, particularly to class actions.
Yeah, and
Is
how
there
do those work out for them? How do those class actions work out for them?
I don't know.
7
the
years
answer
later,
to
they
that,
get
'cause
58 cents, and the
we
lawyers
don't
get
do
wealthy, right?
We get them individually.
Yeah.
And we get a lot of consumer cases and a lot of small employment cases. And there's a feeling out there that somehow arbitrators, because they want to get the next case, are more biased one way or another. And I'm just asking you if there's any evidence of that. I mean, of course, I think there's none, but that's not what people out there say.
Yeah, it's a complicated set of issues that I think is really important, and I think we could do a much better job in the ADR community talking about the benefits to individuals who have the option to go to ADR. In fact, we could actually do a better job telling the story of how individuals in consumer or employment cases fare when they go to arbitration. And the truth is, they usually fare a lot better than if they are in a class action lawsuit and 7 years later get $1.58 for their, and the lawyers get wealthy. But we have not done a good job on that messaging. And another part of the bar has done an excellent job on that messaging. And I think we should take it on the merits and talk about the actual evidence of how people do and make sure we continue to deliver great service and not shy away from that set of arguments. I know I'm getting off, this is like we're going into a whole different topic, but it's a topic I care
Which
about.
we'll pursue in a later program,
Yeah.
for sure. Please join me in thanking the Chief Justice. Fantastic.